I'm Drew Stevenson, and this is a lecture for my administrative law class about Cleveland Board of Education versus Loudermill. This is a 1985 Supreme Court case about due process hearings for government employees. So let's take a look. Loudermill was a school security guard who had stated on his job application that he had never been convicted of a felony. After he had started working there, the school board got around to doing his background check and discovered that someone with the same name had been convicted of grand larceny, a felony in another state. So they summarily fired Loudermill for lying on his job application. He did not have a chance to respond to the charge or the termination. Under state law, dismissal of civil servants could only be for cause, an entitled one to review of the dismissal. Now, Loudermill claimed that this was a mistake or a mix-up with someone else who had the same name, that he actually didn't have a felony conviction. And he claims that the law is unconstitutional because it doesn't provide for pre-termination hearings. In other words, he says this is a due process violation. Now, for my students, please note, this is a consolidated case with another one involving a school bus mechanic who was fired after failing an eye exam and then reinstated a year later at his post-termination hearing. The fact that there's a couple different cases and issues going on in the same case can make it confusing to read when you're a law student or when you're a lawyer. Now, civil servants were entitled to a hearing before discharge if the statute gives them security against firing. In other words, if you have a law that says that government employees can only be fired for cause, we can fire you as long as there's cause. But if we've said that, then you're also entitled to a hearing where you can put on your side of the story about the cause. Ohio law classifies the plaintiffs in these cases, Loudermill and the other plaintiff, as civil servants and says they would not be dismissed without cause. And the court holds that a statute that confers a property right and sets out procedures for enforcing the right, which it did, it gave hearing procedures, cannot limit the constitutionality of the required procedure. The categories of substance and procedure, as the court says, are distinct. Now, I want my students to kind of put this case in the context of the other cases we're doing in our due process unit. This case is we're back to the issue in Matthews v. Eldridge and Goldberg v. Kelly of the timing of procedures and whether the procedural protections in place are sufficient. And specifically, we have a twist on this where the legislature tried to spell out what procedures are adequate for employees. It recognizes that they have a right to a hearing and then says, and this is how we're going to do it. And the court says, the legislature doesn't get to decide what constitutes adequate due process. So let's go back to our slides and look at how we get there. So the statute itself set out the hearing procedures, and these were post-termination. And the big sticking point here is that meant that your salary stopped, your paychecks would stop while you were waiting for your hearing. And the hearing might be 6 or 9 months later. So you were unemployed and not getting paid. And of course, if you got reinstated, maybe they would give you back pay because of the wrongful termination, but that's a long time to have no paycheck. If you were living paycheck to paycheck, you might not be able to pay rent or feed your family. And so they say that the legislature can't authorize a deprivation of a property right after it's conferred without following certain procedures. And those procedures are going to be set by the courts, not the legislature. And the property cannot be defined by the procedures provided for its deprivation. In other words, the Board of Ed argued that we've defined the property right in terms of this set of procedures. The procedures are what created the property right, and therefore you can't discuss one without the others. And the court is very clear that state procedural guidelines cannot foreclose a due process inquiry under the Constitution. And so here's the holding about hearings. And what's nice here and is a useful takeaway for my students, if you're looking for part of the case to highlight or something like that, is where it talks about what we need to have at the pre-termination hearing. And what's a little different about this in our other due process cases is they say, fine, let's break the hearing up into two parts. If you want to have the full-blown hearing sometime later in a few months, that's okay. But if you're gonna stop paying them, you have to give them some kind of quick hearing, at least, before you cut off their paycheck and before you stop paying someone. So we're at least gonna, and this could be almost as informal as a meeting in the supervisor's office. The court calls it a quick check for error. That merely requires some sort of either oral or written notice of the charges against the employee. So if you're getting called to the supervisor's office and you know you're being fired, you need to have been told ahead of time why, right? So that they're not ambushing you there. Some basic explanation of the employer's evidence. So they can't just say something like, you know, a lot of people are saying that you've been stealing money from the company or something like that. That even if they don't disclose names or have proof ready, they can explain, look, 3 different people have come forward with evidence of this, or 3 different people have complained about harassment by you, or something like that. And then there has to be some opportunity for the employee to present his or her side of the story. And if you think about Loudermill here, the court is really thinking about his case, and there's a couple things about the facts of the case that are that really illustrate what they mean here by a quick hearing. So he's accused of lying on his job application, and he says he didn't do it. And the court says, so anytime that this is all about the employee's credibility and whether he's a liar, and you really need to talk to somebody face to face to make that determination. If people, we sense a lot from someone's body language and whether they look us in the eye and things like that, their facial expressions, for whether we think that they are credible. And so that's the first part of what they're thinking here. And this becomes part of the due process jurisprudence later on. The more the case involves a who's telling the truth scenario, the more they want you to have a face-to-face meeting or some sort of actual in-person hearing. And then secondly, this all could have been cleared up if Loudermill had come in and said, I've never even been to the state you're talking about. There's another person with Loudermill and we get mixed up all the time, other person with my name and so forth. And they didn't even ask, right? So imagine an employer who just hears a rumor or something and fires you and doesn't give you a chance to say, no, 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 there's been a huge misunderstanding. That wasn't me, or you have me mixed up with someone else, or you spelled my name wrong, or something like that. And he could have avoided all of this instead of them firing him, making him have no paycheck for months and months while he waits for a hearing where he's going to come in and say, your background check picked up a hit on somebody who just happens to have the same name. And so that's why the Supreme Court is thinking, why couldn't you just give him a quick check for error? But it has to include a chance for you have to let him talk, right? None of this like intimidation tactic that bosses like to do of calling you into their office and saying, you just listen to me, right? I'm going to talk and then throw you out of the office before you have a chance to respond. It has to include some sort of opportunity for you to say, no, there's a big mistake here. The court notes that this can be supplemented by a post-termination hearing that's more thorough. So if we're going to do a thorough hearing later on, then it's okay if this one is brief and is a quick check for error. Now, the plaintiffs here had also contended that 9 months was too long to wait for a formal hearing, and the court kind of rejects that because they say, if we did a quick check for error at the beginning to make sure there's no obvious mistake or case of mistaken identity or mix-up or something like that, then we're not really out the outer limits of how long you have to wait for a hearing. There may be outer limits, but we haven't reached that in this case. Now, we have a set of concurring and dissenting opinions in this case that are actually worth looking at. And I know for law students, a lot of times just skip the concurrences and the dissent because you think, well, they're not the law, right? But actually, these lay out some ways of thinking about due process and explain some arguments that keep coming up in our due process cases. So that this is one of the cases where the concurring opinions and dissenting opinion are worth looking at because they're influential. So Justice Marshall, who at the time was part of the left wing of the court, agrees that the legislature can't basically by statute lower the procedural protections you get, like below what the Constitution requires, which is how the majority characterizes what happened in this case. He also thinks you have to do some kind of pre-termination hearing in order to comply with due process. That's why this is a concurrence. Here's his point of disagreement. He thinks they should have done the full hearing before they stop paying salary, with or without a quick check, right? So if you're going to do an initial hearing, just do the full hearing at the beginning. But he says if there's a substantial dispute in the evidence, if there's no real disagreement and we're just talking about sort of the equities of the situation, that's one thing. But if there's a case that your background check just picked up a false hit, that's kind of a big thing that we could have determined. And he says, look, the employee's interest in maintaining his job is substantial and he depends on the accuracy of these pre-termination proceedings. Now, Brennan, who usually concurs or dissents with Marshall, has his own concurrence and partial dissent here, where he says he agrees that with the holding that there should be a right to notice and opportunity and so forth, rather than something granted by legislation. His disagreement is with the idea of what procedures are required in specific cases. He thinks if there's no formal factual dispute, then we don't really need any formal procedures, that the procedures are really there when there's actual questions in dispute. And he thinks there's going to be lots of cases where there's no real factual dispute. It's just about the rightness or wrongness or justness of it and so forth. And maybe we don't need a hearing for that. He said the court should have done a more fact-intensive analysis of whether the post-termination hearings were delayed so much that they violated due process. Now, Rehnquist has a very interesting dissenting opinion, and I call this like what the legislature giveth, the legislature can taketh away. And he says the property right and the due process right both come from the statute. So if the statute creates the property interest, that's the more accurate thing to call it instead of right, then they should also be able to define the procedure. The state's definition of the property right, it really should say interest, that it creates should be recognized. Now, to connect us with our other cases, remember this is about due process for employees, and that is something it has in common with Roth and Sinderman. On the other hand, it's about the timing of the hearing, which is similar to Goldberg and Matthews v. Eldridge. Here's a little some concluding thoughts. Although the court reiterates the property, it can be created by state law, by statute that limits the procedures governing the termination. The procedures themselves are irrelevant for deciding whether you have a protectable property interest in your job. Why? According to the court, the scope of constitutionally required hearing elements must be determined independently of state law once due process is triggered. In other words, if we're talking about constitutional due process, we're going to ignore what the legislature thinks your process should be. In other words, once the criteria, the substantive criteria specified in state law would confine the decision-making discretion so that there exists rules or mutually explicit understandings that support the claim to a benefit that someone may invoke at the hearing, the state cannot set the features of that hearing below a constitutionally required level. Now, here's our quick review question. Which of the following is not one of the elements of a preliminary hearing prior to for-cause termination of government employee required by the Supreme Court? A, the opportunity to cross-examine adverse witnesses and present impeachment evidence. B, oral or written notice of the charges against the employee. C, a basic explanation of the government employer's evidence for the alleged wrongdoing, or D, an opportunity for the employee to present his side of the story about the incident. This was supposed to be an easy question, and hopefully you know the answer. If you're not sure about this, either pause the video and read it again. You may need to rewatch the video if you're stuck on this. Okay, that concludes our lecture about the Loudermill case.